your question is quite interesting. And I know that there's going to be case law that you're going to be referring to, but obviously, when entering into lease agreements and when a landlord wants to let out their property, the question always comes up on whether the Consumer Protection Act applies or whether it doesn't apply. And I mean, this notion of, yeah, but it's my house, it's my only property, certainly the CPA doesn't apply. So I think it's very important here because the question is around a landlord that temporarily can't use their property, but intends to do so later. So it's almost like a temporary fix, letting it out for the short term, but not with the intention of doing this permanently. So maybe just give us a bit of insight. How does this work? When does the CPA apply? Is it safe, or are there any tests? What do we do?
Perfect. So we've talked about the Consumer Protection Act a lot on this particular channel. And generally, we focus on something like Section 14, which relates to fixed-term lease agreements. And we do our best to try and give you guys bite-sized information, make it palatable for you. But the truth is about the Consumer Protection Act that even though we try and give it to you in a nice format, it's a lot more complicated. And the act is a lot wider than sometimes we deal with on this particular channel. And this is where the question comes in today, where someone is leasing out a property, they're not really using it for a consumer purpose. So they're trying to avoid the provisions of the Consumer Protection Act by saying that they're not using it in the ordinary course of business in the circumstances. And that's why they're trying to avoid the Consumer Protection Act in the circumstances. And there is a recognition within the Consumer Protection Act where someone is doing something that's not in the course of their business, the act should not actually apply to them. So in our particular circumstances, we're talking about services. When you are providing a lease property to someone, you are providing a service, and there is a recognition you're supplying a service, and there's a recognition within the act that supply must relate to an ordinary course of business in the circumstances. The Consumer Protection Act is not going to apply to circumstances where you're not doing this for a business purpose, okay? Because that's what the act is trying to deal with. So now we get many questions about, well, what does that mean? What does in the ordinary course of my business mean? And people who try to say that I don't fall under the ambit of the act because I'm not actually supplying a service. And we thankfully have had case law where courts have considered this question about, well, what does this ordinary course of business mean? And there is case law where in a particular stated case, there are parties who had a rental, they were in the process of determining whether they wanted to, in fact, immigrate from the country or not. And in this particular case, they'd gone to Australia, but they weren't convinced that they were actually going to vacate or leave the country. And so what they did is during that interim period where they had merely gone to Australia to go see whether this is something they wanted to do, they decided they were going to rent out their home. Okay, so this is not another property that they had been renting out for a long period. This was the home that they had lived in while they were in South Africa. They decided instead of just leaving the home there, they would rent it out for this interim period while they were outside of the country. So it was by no means a permanent thing that they were doing. They still had the intention of coming back after they had decided, and this was something that they had used as their home. And in these particular circumstances, the court actually made the determination that once you look at the intention of the parties in those circumstances, it was clear that they were not intending to actually use this property for a business purpose. The purpose that they had rented out the property was just to put someone in occupation of their premises on a temporary basis while they were in the process of seeing whether they would like to immigrate or not. And on that basis, the Consumer Protection Act did not actually fall under the definition of a service that they were using in the ordinary course of business. Okay, so what's important to know about this is it requires a specific set of circumstances, okay? It's a very specific set of circumstances in this case that they could demonstrate that they weren't doing this as an ordinary course of business. Most of our clients, most people entering into lease agreements, you're not going to fall into this very specific set of circumstances. And this is why we try and make Section 14 a bit palatable and say you need to consider it without dealing with this. But in specific sets of circumstances where you can show that you're not doing this in the ordinary course of a business purpose, there is the ability to escape the provisions of the Consumer Protection Act. And specifically in the question that we've received today, we're told that someone has entered into a lease agreement in respect of their property that they have for a 1-year period, but it's not because they're intending to use that property for a business period. They just happen to be renting, and their lease periods, they don't want to terminate early. This is the balance of the lease period that they have before they move into their particular property. And so can they avoid the provisions of the Consumer Protection Act? Now, I'm not going to espouse any conclusion on the particular matter because, as all things are, it depends on the circumstances. But I can say that the facts that are given in this particular case, there may well be an argument to say that this is not actually in the ordinary course of business. This person's buying the property, they're intending to live in that particular property, and what they are doing is they are, instead of terminating their existing lease agreement that they had at the time they purchased this property early, and obviously then incurring cancellation penalties, etc., they are simply going to let out their home that they intend to move in for a short-term period before they can themselves move in. And there's certainly an argument there to say that the Consumer Protection Act will not apply in those circumstances.
Absolutely. I agree. Thank you so much, Nick.
Perfect. Thank you, Bruno.
Great.
And we will see you next week.
Have a great day.
So, cheers.